on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area.
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer. I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
it just happened right before your eyes. Good luck to you.
We're about to go to war.
This one gets crazy real quick. Judge Urich isn't the type to mess around. He's dealing with a guy who claims to be a sovereign citizen, and honestly, it's hard to tell if he's pretending to be insane or actually lost it. He's in court for 2 counts of public indecency after being caught doing nasty stuff in a park. Let me know in the comments, is he acting or just out of his mind? And if you enjoy wild courtroom moments like this, make sure to like and subscribe. Let's get into it.
Mr. Stringer does not acknowledge or consent to this hearing. Is that correct, Mr. Stringer?
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer.
Very well, Mr. Stringer. The court is going to read the charge into the record since the formal reading is not waived. Mr. Stringer, on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area, contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent B. The court advises you that this is referred to as a Tier 1 offense under the Sex Offender Registry Act. There is a count 2 misdemeanor in that on the same date you did knowingly make an open or indecent exposure of your person contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent A, commonly known as indecent exposure.
Sir, excuse me, sir. You have not talked to my beneficiary yet. You have not talked to the person who owns the estate yet.
Mr. Angot, the court is making a notation of court-appointed counsel to run through the IDSO office, and that new counsel, as appointed by Mr. Mena, can make whatever judgments they wish to make and make any motions they wish to make at Mr. Stringer's first probable cause conference. Mr. Stringer, this matter is now being set for a probable cause conference. That will be on a new date. The law entitles you to what they refer to as a preliminary examination within 21 days of this arraignment today.
He also has a lengthy criminal history out of Texas, going from as recent of these warrants, which were entered last year, back to around 2015, receiving charges for evading arrest and detention, unlawful possession of a firearm by a felon, assault, family, house member, impeding breath or circulation, several other assault charges, a weapons charge, and then also like falsifying assault from 2019 out of Hartwood Woods, which looks like it was deferred as assaulting a public officer or obstructing.
Judge, despite the fact of these charges and what was listed by the detective, I believe that with the GPS tether, that certainly would give this court, pretrial services, and any other entity overseeing Mr. Stringer during the pendency of this matter, notice of where he would be within 3 feet, is my understanding, with that tether. I don't think a cash bond is necessary. I would ask the court to give him a personal bond with the GPS tether.
Given everything that's before the court at this time, the court will set bond in the amount of $50,000, cash or surety, no 10% allowed at.
I've got to give credit to this judge. He's really good at keeping control. A lot of judges lose patience with these sovereign citizen types, but Judge Urich keeps it cool and cuts through the nonsense right away. The way he calls them out is actually hilarious. Calm but harp, that $50,000 bond? Totally fair. The guy's got a bunch of felonies already, and he's still young. Definitely not someone who should be out right now. Hopefully he learned something, but honestly, I'm not sure. He might be mentally unstable, or just playing dumb. What do you think? Let's get back into it.
If Mr. Stringer wishes to bring various motions before the examining judge, and that could include a motion to modify his bond, that is his right and his privilege, but at this time, that is the bond as set by this court. Mr. Stringer, that concludes your arraignment, sir.
Sir, so I can't get out on a personal bond?
That's correct, Mr. Stringer. You cannot get out on a personal bond. 50,000 cash or surety with the appropriate conditions that were already listed by the court. That completes your arraignment, sir.
Sir, so what is going on with the, what is going on? Right?
I'm sorry, sir?
I'm being charged. I'm being charged with entity that is.
Can you please move up so the court could hear you?
I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
It just happened right before your eyes. The court has jurisdiction over you, sir. Venue and jurisdiction have been established by sworn testimony. That completes your arraignment. Good luck to you.
We're about to go to war.
Did you hear that? He literally told the judge, "We're about to go to war." I mean, who says that in court? That's just asking for trouble. If I were the judge, I'd hit him with contempt on the spot. Anyway, now we're heading into his second hearing, this time with a different judge who doesn't take any of his nonsense. Things heat up fast. What did you think of the first one? Let's jump right in.
All right, Mr. Stringer, state your name.
I don't acknowledge myself as Derek Stringer. I'm a living entity.
Okay, is there another name that you go by, sir?
A living entity, I'm the beneficiary, so I go as a job. And I want to fire that counsel. I don't want him.
All right, so there's a number of things to unpack here. All right, so let's walk through this. So did he make it known to you that he wished to no longer proceed with your services?
Judge, we discussed the case fully, and I had a lengthy phone call with one of his relatives, and it was my intention to ask the court to refer this to the Forensic Center for a competency evaluation.
I do think it, given your experience and then your connection with him as well as a family member, plus the way the defendant has presented today, that a competency review is in order. And so I'm happy to move forward with that. So Mr. Stringer, there is, just so you understand, there has been some preliminary information that suggests that you may not be competent to proceed at this particular time. Whether that's a correct assertion is basically a decision that can only be made after an investigation is done to determine whether or not you can, that you understand the nature of the proceedings, that you can assist your attorney. We need to find those things out. And so, Ms. Mott-Lewis, can you prepare an order for competency review?
So now the judge wants to see if this guy is mentally fit for trial. When someone fires their lawyer but might be mentally off, it's a huge problem. If they're not stable, they can't defend themselves, and the whole case could fall apart. This guy thinks he's super smart, but it's clear he's not thinking straight. It just slows everything down. The judge explains that being competent means you understand what's going on and can help your lawyer. But this guy keeps rambling, saying his lawyer didn't call his dad and that he wants him gone to this point. It's obvious. The judge is right to question his mental state.